It's my distinct pleasure this year to have the honor of introducing our keynote speaker, Dawson Horn. Welcome, Dawson.
Thank you very much, Bill.
Dawson is presently the president of Network for Excellence in Legal Technology, NEXT, where legal tech innovation meets inclusive excellence. He's also on the board of the Practicing Law Institute and the advisory board for ALM's Legal Week. This is what Dawson is doing in retirement. He was previously Vice President, Associate General Counsel to the Litigation Department at AIG, where he was responsible for specified corporate cases, a range of eDiscovery matters, and antitrust compliance. Before assuming that position, he was Senior Litigation Counsel for Tyco International and was responsible for large toxic tort and insurance recovery cases. Prior to that, he served for 8 years as Assistant General Counsel for Altria Corporate Services, where, among other things, he managed the defense of their multi-billion-dollar RICO litigation brought by the Department of Justice against U.S. cigarette manufacturers. And at Scott Paper, he managed the company's defenses in breast implant cases and litigation and navigated its related issues. You know, I think I handled a bunch of your cases.
That's why we won.
His litigation training began at Pepper Hamilton, no connection, no association, where he gained first-chair trial experience and worked primarily on insurance and antitrust cases. Dawson's a frequent speaker on eDiscovery issues and has spoken at Legal Week, as a Sedona Conference, and Electronic Discovery Institute. He also teaches, on top of all that, at Temple University, which I'm very proud of, coming from Philadelphia, my hometown. Great university, great college. So we have a wealth of experience before us, and Dawson, Mr. Horn is going to be speaking to us about the challenges we're facing, what the future may look like, and how we can make sure we're prepared for it. Thank you very much, sir.
Bill, thank you.
Yeah.
First of all, let me thank Bill and the University of Florida eDiscovery Staff Planning Committee for inviting me. It's an honor to be here, also very frightening. Like most things, when you accept it some months ago, it seemed like a good idea. Around Christmas, I began to kind of sweat about this, and over the past 2 weeks, I've been making my wife crazy. I'm also glad to hear from Maribel that the chat function is up and going, because my wife, if she's listening, I expect her to be logging in frequently and making comments. I'm here because, though primarily as a litigator, legal tech has been a constant throughout my career. Undoubtedly, I'm here today, as Bill introduced me, because in my role as president and co-founder of the nonprofit NEXT, Network for Excellence in Tech Law. Broadly, NEXT's mission is to improve the legal tech space through education and inclusion of a diverse cohort of qualified professionals. So maybe then, I should start with the definition of legal technology. I mean, it's not only in our name, it's in, as Bill pointed out, our tagline. Next is where legal tech innovation meets inclusive excellence. The idea of legal tech is that it utilizes advanced technologies to support tasks within its legal context. Its goal is to assist and support legal activities, enhance the efficiency of legal work, and potentially transform the modes of legal service and the landscape of the legal industry through the use of these advanced technologies. Over the past 3 years especially, and as Bill pointed out in his introduction, the pace of new developments in legal technology has been moving at an astonishing pace. And the most exciting technology goes by just its initials, AI. It's kind of the prince or share of the legal technology space. But as exciting as all this is, it does fairly give us pause. And it's how we should balance that excitement and that pause that I think Bill has asked me to speak to. So let's begin by setting the stage with some definitions and an understanding of how pervasive this new technology really is. Broadly, artificial intelligence refers to the capability of a machine or a computer program to perform tasks typically that require human intelligence. Such tasks include problem solving, learning, understanding natural language, recognizing patterns, and decision-making based on a set of data. Evidencing the pervasiveness of its impact on the worldwide economy, the global AI market was valued at about $454 billion in 2022 and is expected to contribute nearly $16 trillion to the global economy by 2030. But driving these numbers is that particular branch of AI known as generative AI or Gen AI, first introduced to the consuming public in 2022 by OpenAI in the form of ChatGPT. As most of you have already experienced, AI technologies like ChatGPT can generate surprisingly human-like answers and sensibly respond to natural language instructions. For example, in response to an instruction or a prompt, ChatGPT can answer everyday questions, write stories or a poem, help plan a trip, explain complex concepts in plain language, carry on a back and forth conversation that feels natural rather than mechanical. And it can perform these tasks faster than it takes you to refresh your inbox. ChatGPT quickly turned into a worldwide phenomenon. It reached 1 million users within 5 days of its offering, faster than any other popular online offering, including Spotify, Facebook, and Instagram. 2 months in, it had reached 100 million users. The excitement around Gen AI has infiltrated the legal community. In a recent survey by Thomson Reuters across all legal industries, a vast majority of today's professionals, 89%, say that they see a use case for Gen AI within their work. And beyond that, legal professionals have concluded that Gen AI will not be a flash in the pan, but it will be with us for some time to come. When asked how quickly they expect Gen AI to become a central part of their organization's workflow, respondents were unequivocal. Gen AI is set to take center stage quickly, if it has not done so already. Across the legal industry surveyed, at least 1/3 of respondents said they believe Gen AI is already a central part of their organization's workflow or is set to become so within the next 12 months. Additionally, more than 1/3, 34% of all respondents said they believe that will happen within 1 to 2 years. So taken together, this means that 95% of all professionals believe that Gen AI will be a central part of their organization's workflow within the next 5 years, while just 3% believe that will never happen. But some may subscribe to that well-worn judicial truism, money talks and BS walks. Well, looking at where the money is flowing, any legal professional ignores this movement at their own risk. The legal technology market hit $32 billion in 2024, growing at a 9.4% annually toward a projected $64 billion by 2032. This is disruption truly at a global scale. For those of you who may revere the saying, may you live in interesting times, well, you have found it, my friends. Against this backdrop, for those of us in the legal technology space, all of this is really exciting. But again, it's also anxiety-producing. So, in my address, I will discuss how do we embrace the technologies that generate this excitement? And I will argue that we must embrace them. And second, I will address the issues of unease or anxiety, which I believe takes 2 forms. First, there is the legitimate personal uneasiness, as those of us in the profession or those of us who are about to become members of the profession have legitimate concerns about what this means for our livelihood. And second, there is a professional unease. What does this technology mean for the bedrock principles of our profession? The preamble to the ABA Model Rules of Professional Conduct tells us that we are to seek improvement of the law, access to the legal system, the administration of justice, and the quality of service rendered by the profession. Because I submit technology in general, in particular AI, and in particular generative AI, is relevant to each of these 4 obligations. part of our discussions about AI should be how we are ensuring that we are using it in a manner to further those obligations. As we navigate these often conflicting concerns of excitement and anxiety, I believe we can rely on and hearken back to some enduring truths of the profession generally and enduring truths of the legal tech space in particular, as North Stars to guide us through. Truths like, first, we must be seriously committed to an education that is truly continuing. We will always be faced with new issues to address and new problems to solve. Legal technology is not different. Neither the technology nor the law are standing still. Therefore, neither can we. Second, it is central that before adopting any technology into the legal tech space, we subject that technology to rigorous processes and testing. The key lesson from the eDiscovery evolution is that a pragmatic approach to AI adoption. eDiscovery professionals learned that machine language models require continuous validation, auditing, and human oversight. Lessons directly applicable to AI in the legal practice. And as a third truth, we must uphold the principles of our profession, which I've summarized earlier from the model rules. These principles are the lens through which all other concerns are evaluated and pursued. So, we've defined our first truth as education. Let's start there. And just as every brief starts with a statement of facts, we need some facts about how the machine works. What is the technology under the Gen AI hood? But before doing that, let me begin by apologizing to two groups. My wife told me it's always a good idea when I'm starting to explain to apologize first. First, I apologize to those of you who are already well-versed in AI technology, and this may be just another version of what you have already seen and know. The second group I want to apologize to are those of you who are newer to the area and for whom this discussion may be more computer science-y than you had anticipated it be. Apologies notwithstanding, I ask both groups to bear with me for a bit, as I think we need a common ground about how the machine works so that we can wrestle with two overarching issues that have great legal implications. The first issue is this Gen AI machine thinking? The second issue, whatever the hell it's doing, for any given inquiry or prompt that we put in, can we explain or map or diagram the steps the system took to generate its ultimate output? So to begin, ChatGPT and subsequently developed generative AI technologies such as Anthropic's Claude rely on large language models or LLM technology by which they understand and generate human-like text, but also videos and images. The GPT stands for Generative Pre-trained Transformer, which refers to the processes that request and formulates the response. You see, the way we interact with the LLMs, reinforced by having assigned them a moniker of human attributes, human intelligence, leaves one with the impression that the LLM is thinking, kind of like Hal in that old movie, you know. But that's not true. Despite the hype, large language models are just computational programs that predict a sequence of words as predicated by the preceding words. To teach AI to understand and generate human-like writing, it is trained on massive amounts of text and various sources such as websites, books, and other digital content. This pre-training, unlike earlier forms of AI, is unsupervised, which means AI doesn't need the data to be carefully pre-labeled by humans to facilitate the training. Instead, by analyzing the examples we've provided it, AI on its own learns to recognize patterns, structures, and context in human language. Remarkably, with a vast number of adjustable parameters called weights, the LLMs can create a model that emulates how humans communicate through written text. The weights are complex mathematical transformations that LLMs learn from reading the billions of words, and they tell how likely different words or parts of words are to appear together or in a certain order. The original ChatGPT had 175 billion weights, encoding the connections between words and parts of words. And no one programmed these weights. Instead, they too are learned by the AI itself during its training. Thus, and somewhat counterintuitively, when ChatGPT appears to be answering a question or producing a document such as a poem or a legal motion, it's actually using its internal AI system to predict the next most appropriate word, to generate the next word one word at a time. Ultimately, that is all ChatGPT does. Act as a very elaborate autocomplete, complete like the one you have on your phone. You give it some initial text, and it keeps writing text based on what it statistically calculates as the most likely next word or part of a word in a sequence. Even when generating lengthy documents or comprehensive answers, it still operates by generating text incrementally, predicting one word at a time based on what it has been asked or instructed. Fluency, not necessarily accuracy, is the underlying principle of how the LLM works. But there is yet another level of abstraction. You see, for computer systems to exhibit understanding and sensible generation of text in a natural language such as English, they must convert natural language, the words, the paragraphs, etc., into a form of representation on which mathematical operations can be performed. That is a two-step process. The first step is tokenization. This will be short, hang with me. Tokens are the smallest unit in the text that represent content. Sometimes they correspond to full words, but often they correspond to subwords or parts of words. Tokens are the representations that LLMs use to break text into pieces that can be encoded as numbers. GPT-4 is expected to have been trained on a set of about 13 trillion tokens. Multiple numbers represent each token to capture the nuances of meaning and relationships between the tokens. This list of numbers is called a vector. Hang with me. Once the model has been trained, it can be used to generate text in response to a prompt. When the prompt is presented, the model's sole capability is to predict the next token. By designating the appropriate prompts, the model can be made to perform a large number of nominal tasks. But underlying these putative performances is just the language model predicting the next word. The model produces the next token according to the patterns encoded in the connection weights. It predicts the next word solely based on the numerical vector and the connection weights in the neural network. Okay. So we leave this tech discussion, I hear the applause, with two overarching understandings. The LLMs are not thinking. And as a practical matter, because the LLM does so much of its work on its own, we cannot step by step map how it gets from prompt A, plan me a trip to New York, to output A. Here is the itinerary we want you to use. So having established these factual predicates and put these stakes in the ground, let's turn to the legal applications and applications. To start with a duh statement, the overwhelming consensus is that advancement in AI will prove pivotal to the legal field. Duh, that's why Bill invited me here. The ability of the technology to analyze increasingly large quantities will be a force multiplier for lawyers. Let's quickly walk through a few examples. And since we are at the University of Florida's eDiscovery conference, let's start with eDiscovery. Generative AI is adept at rapidly parsing extensive data sets and synthesizing the information. The first mainstream use of AI in the law has been in eDiscovery, in which mountains of pretrial documents can be analyzed to identify relevant sources and evidence in litigation. At the so-called first level stage of review, Gen AI can provide a rationale as to why a particular document is relevant and needs to be checked. Relatedly, if an initial set of search terms that we turn loose on a large mountain of documents uncovers a large number of documents which produce a hit on that search term, but are not relevant, in other words, produces what we call a low precision result, generative AI prompts can quickly be adjusted to give us ways to increase that precision. Generative AI can also be used as a gotcha check against an unscrupulous opponent to quickly determine whether that opponent in their production has truly responded or has merely made a document dump. Legal research and drafting. Generative AI brings us to the era of prompt-based searching, where technology understands and responds to inquiries in a conversational process, and so exponentially increases the speed and efficiency of that research. Then, with research results in hand, one can move seamlessly to legal drafting with generative AI. Generative AI can be used to automate the creation of legal documents such as motions, briefs, wills, letters, and can be used to review or customize existing documents. By learning from previous documents and preferences, AI can suggest changes or additions to the document once better suited to the user's needs. M&A and due diligence. In a typical merger and acquisition, deal rooms are filled with expensive documentation such as financial records, intellectual property information, compliance documents. Generative AI models can be trained to sift through this plethora of data, identifying key information for us, flagging potential issues, and summarizing relevant findings. This capability greatly increases the due diligence process, which is traditionally time-consuming and labor-intensive. Contract analysis. Many of the same applications I discussed in M&A can be used by contracting and procurement teams. But further, such teams can employ document automation tools designed to simplify the creation of legal documents through customizable templates and conditional logic. And there are tools that can improve contracts, can compare contracts against predefined policies and flag variations. Cybersecurity and data response. AI can play a significant role identifying personally identifiable information, that's PII to all you privacy geeks out there, during the reporting process in the response to a data breach. This is particularly important because quick and accurate identification of the information that has been compromised is crucial for determining the appropriate response measure, including who needs to be notified and what regulatory filings may be required. Legal operations. In traditional legal operations, matter management solutions often offer centralized dashboards and case updates, document sharing, and deadline tracking. AI enhances these platforms by prioritizing urgent matters, suggesting task sequences, and forecasting resolution timelines. Billing and timekeeping are often subsumed as part of the legal ops function. AI allows one to effectively interrogate time entry and billing submissions to verify accuracy, highlight duplicates, and compare to contractual billing guidelines. Governance and compliance. The first stage of any information governance implementation is data classification. Without accurate and appropriate classifications, information governance functions cannot work. Traditionally, classification was a manual process, but AI-powered systems are now available to automatically classify records using a combination of predefined taxonomies and machine learning techniques to parse the information within a record and apply one or many classifications. And as to compliance, AI chatbots can quickly answer compliance and ethics questions with human oversight, offering reliable information and reducing the risk of non-compliant and unethical behavior. In summary, generative AI harbors the real potential for reducing the human capital needed to handle cases involving large quantities of documents, many parties, and complicated claims. Generative AI, thoughtfully applied, appears poised to improve upon existing eDiscovery techniques, while also lowering the expertise value for effective use. It also seems likely to improve upon the state-of-the-art in legal research and increase efficiency there. And its assistance with drafting may significantly cut the number of hours devoted to those endeavors as well. Wow. Why did Bill ask me here? This future is just flat exciting. And indeed, I suspect many a self-proclaimed futurist would be prone to ask, if the future of AI in the legal profession is this rosy, aren't we able to much more exclusively rely on this new technology? For that matter, why do we need lawyers at all? If that were true, Bill would not have asked me here. So now, having some background not only on how the LLMs work, but also how they can be used in the law, let's kick the tires and see what happens when we test that futurist's premise. When we do that, we start to see some imperfections. The first, hallucinations and related inaccuracies. Specifically, LLMs, for all of their positives, possess a propensity for generating unreliable output that poses a substantial risk in legal context. That's my second duh statement for the. Broadly, that propensity has been defined called a hallucination. Again, kind of part of our giving this artificial intelligence a human attribute. A lot of people use the term AI hallucination, but many don't clearly understand what it actually means. In simple terms, AI hallucination is when the model produces information that sounds confident and well-structured, but is actually incorrect, fabricated, or impossible to verify. This includes things like made-up academic papers, fake book references, invented historical facts, technical explanations that look right on the surface, but fall apart under real checking. The real danger is not that it gets things wrong, it's that it often gets them wrong in a way that sounds extremely convincing. One of my colleagues and mentors had a phrase. He said, "Dawson, don't let my confidence lull you into a belief that I'm right." I picked that up. Most people assume hallucination is just a bug that engineers haven't fully figured out yet. But in reality, it's a natural side effect of how the large language model works. Remember, these systems don't decide what is true. They predict what is most statistically likely to come next in a sequence of words. When the underlying information is missing, weak, or ambiguous, the model doesn't stop. It completes the pattern anyway. The well-publicized case of Mata v. Avianca has thrust hallucinations into the legal spotlight. In that matter, the plaintiff's counsel used ChatGPT to draft a brief that relied on half a dozen legal decisions and arguments. Unfortunately, and as we all now know, each one of them was fictional. ChatGPT further hallucinated the decisions themselves, allowing realistic citations when it was asked for the content of the decisions. Given what we know now, this result should not be surprising, as studies have revealed that so-called general-purpose LLMs hallucinate legal queries on an average between 58 and 82% of the time. Recently, certain legal technology providers have put forth solutions employing an approach called retrieval augmented generation. That's RAG to us cool kids. aimed at mitigating the hallucination's risk. Research suggests, however, that this is far from a panacea. In a recent paper from the Journal of Empirical Studies entitled Hallucination Free, Assessing the Reliability of Leading AI Research Tools, the authors put forward a definition of hallucination to be applied to the legal community. They define hallucination as a response that contains either incorrect information or a false assertion that a source supports a proposition. Applying this definition to 3 tools, they found the following accuracy rates: 65%, 41%, and 19%. If ever there was a cautionary tale, this is it. Along with inaccuracy and hallucinations, the potential for bias in the use of generative AI and its output is an ever-present concern. AI models are susceptible to bias based on the data they are trained on, and there can easily be historical and societal prejudices embedded in that data. Notably, much of the training comes from the open web, which is nobody's idea of a non-toxic, bias-free, and friendly place to work. In the legal context, biased AI models can perpetuate or even exacerbate disparities in the justice system. For example, if the training data used to develop an AI system includes biased decisions or discriminatory practices, the model may inadvertently replicate and perpetuate those biases in its predictions or in its recommendations. Consider that a 2023 study by Bloomberg found that Stable Diffusion, a popular text-to-image diffusion AI model, amplified stereotypes about race and gender, depicting higher paid professions as whiter and more male than they actually are. When asked to show a judge, AI generates a picture of a man 97% of the time, even though 34% of US judges are women. In showing fast food workers, 70% had darker skin tones, even though 70% of American fast food workers were white. Another concern is how the use of generative AI in the legal practice poses significant challenges to a lawyer's compliance with their ethical obligation to maintain client confidentiality, which is a cornerstone of the lawyer-client relationship. The sanctity of this relationship is based on ensuring that sensitive and privileged information shared by clients remains secure and confidential. However, the inherent nature of generative AI, which often requires access to large data sets for training and manipulation, raises concerns. For example, if a lawyer uses generative AI to draft documents or to conduct legal research, there is the potential risk that AI model tool inadvertently discloses sensitive information, particularly if the AI learns from or accesses the underlying document that contains the sensitive data. Indeed, just this month, confidentiality issues in the AI context were discussed in the case of US v. Hepner. In Hepner, the defendant sought to have his engagement with Anthropic's AI Claude privileged. That was easy for you to say. While there is a lot to digest in the opinion, and many of the court's conclusions can fairly be read to be fact-specific, for purposes of our brief discussion here, it is worth noting that central to Judge Rakoff's rejection of the defendant's privilege claim was his finding that Hepner could have no reasonable expectation of confidentiality in his communications with Claude. Last, turning to the final shortcoming that I will discuss here, it's the so-called black box issue and algorithmic opacity. The concern here is that for us, in the legal profession, where transparency and trust are foundational to ethics and effective practice, explainability will, in many instances, be pivotal for the responsible adoption of LLMs. Legal professionals rely on clear, reasoned arguments and justifications for their decisions. Even in our eDiscovery world of technology-assisted review, TAR for all of you folk out there, we check the tool's conclusions by an evaluation of the documents found not to be relevant, the so-called null set, to make sure that in the processing, the system has not missed relevant documents that should be in line for production. Algorithmic opacity occurs when the rationale behind an AI's decision-making process is incomprehensible to humans. This stems from the technical intricacies of the AI system. Aren't you glad we discussed those now? And other elements of traits like trade secrecy. Even if one were to be perfectly educated about LLMs, the fundamental nature of the systems means that there will always be a blind spot in the AI process. As previously mentioned, AI technologies are essentially pattern recognition programs, which use their patterns to generate the output. This makes AI tools incredibly powerful in recognizing correlation, but not necessarily causation. As such, while we can observe what data is entered into the AI system and what the output is, it's impossible to ascertain exactly how exactly any given input is processed or why that process was applied. My friend and colleague, Judge Rodriguez's discussion in the Sedona Conference Journal of the case Houston Federation of Teachers versus Houston Independent School District is instructive. There, the Texas District Court held that the school district's value-added appraisal system for teachers posed a realistic threat to protected property interests because the teachers were denied access to the computer algorithms and data necessary to verify the accuracy of their scores. That was enough to withstand summary judgment on their claim for injunctive relief under the 14th Amendment. Even where the output of a computer technology is not being used as direct courtroom evidence, one can see how opacity can render the output suspect and, at a minimum, require further verification. So, where does this leave us? We've demonstrated AI's great capabilities in the area of productivity and efficiency, but we've also peeked behind the curtain and exposed its real shortcomings. The tool is too powerful and harbors too much potential for bettering our profession to be left on a shelf. And even if we wanted to, societal pressures would not allow it. AI, my friends, is here to stay. With all of this background, then where do we fall on the scale of AI-related personal anxiety? For many, I suspect, with every announcement of automated contract review, accelerated due diligence, streamlined compliance monitoring and generated legal drafting, there is a hint of personal anxiety or a ripple of unease. Will AI replace junior lawyers? Will prompt engineering eliminate paralegals? Will AI supplant legal operations? Could AI make entire legal functions redundant? And to be fair, that anxiety has been exacerbated by so-called pundits. One 2023 analysis is to have estimated that as high as 44% of the tasks currently performed by legal professionals can be automated. But having completed the research for this address, and having spoken to numerous colleagues, I'm not convinced that this approach withstands scrutiny. And to the contrary, I believe a more nuanced analysis is required. And I'm not alone in suggesting that concerns of a lawyer Armageddon are overhyped. A Thomson Reuters study put it this way: since its release, many have speculated as to whether Gen AI will cause job loss, impact bottom lines for companies or firms, or cause the demise of professional services altogether. In actuality, however, and admittedly one can argue that we are still in the early stages, few professionals have actually said that they believe Gen AI is a major threat. In one study, relying on qualitative interviews from persons responsible for AI deployment from 10 AmLaw 100 firms, the author found that even with all of this smart software assisting lawyers, none of the firms interviewed are anticipating any reduction in the need for the number of practicing attorneys. Even acknowledging the anecdotal nature of those results, the author found that associate hiring and lateral movements have not been affected by the expected inclusion of AI capabilities available to practice groups. Particularly insightful, one of the interviewees stated that even with our AI initiatives, we just brought in the largest associate class in the history of the firm. And to be fair, while we can see intermittent articles referencing AI in connection with law firm restructuring, it does not appear that AI is the significant driver to job reduction associated with that restructuring. So looking at all this, I agree with the conclusion that the future of law will not be defined by technology replacing professions. It will be defined by how effectively professionals use AI technology to amplify expertise and how responsibly they manage the associated risks. Okay, a fair rejoinder to that conclusion may be objection, conclusory, or assume something not yet in evidence. Fine, I've been through a deposition before. Let's look at what we have learned thus far, though. First, AI is not thinking. At its core, it is autocomplete on steroids. Second, it hallucinates and gives false answers. And it's particularly susceptible of errors in legal analysis, where the stakes are especially high. Three, its answers can be infected by an impermissible bias, further impugning the credibility of its output. And there are a range of other challenges, like the degree to which AI can be trusted with client confidences and whether it is sufficiently transparent to meet the concerns of our legal community. But perhaps most significantly, while AI at first blush may seem capable of realizing Max Weber's vision of a legal vending machine, perhaps its most significant shortcoming is that it lacks the human capacity for moral judgment, the ability to navigate complex trade-offs among conflicting values, and the insight required for nuanced legal reasoning. These are the things that are the unique province of the experienced and well-trained lawyers, things that are happening at places like this, at schools like this. So while AI can be a powerful tool, remember, it is just that, a tool. Let me say it again. The real advantage of AI is that it amplifies human capability rather than attempts to replace it. Indeed, I submit, the greatest danger presented by AI may be an over-reliance on it, an over-trust, a tendency to over-delegate. In short, AI is not plug and play. There must be a human in the loop. The requirement of a human in the loop is not just my opinion, but it's reinforced by ethical rules. The American Bar Association model rules establish critical frameworks for AI adoption in legal practice. In July of 2024, recognizing that generative AI in particular raised, quote, important questions under the ABA model rules of professional conduct, and that Gen AI tools are a moving target, indeed a rapidly moving target, that's from the text, the ABA issued formal opinion 512. The opinion begins with the discussion of a lawyer's duty of competence as set forth in Rule 1.1. Model Rule 1.1 requires lawyers to understand the benefits and risks associated with the technology used to deliver services to clients. To achieve the requisite level of confidence, the opinion states, lawyers need not become experts in Gen AI. Rather, lawyers must have a reasonable understanding of the capabilities and limitations of the specific GAI technology that the lawyer might use. This means that lawyers should either acquire a reasonable understanding of the benefits and risks of Gen AI tools that they employ in their practices, or draw on the expertise of others who can provide guidance about relevant GAI tools' capabilities, and limitations. The opinion specifically notes that because Gen AI tools are subject to mistake, a lawyer's uncritical reliance on content created by a Gen AI tool can result in inaccurate legal advice or misleading representation to courts and third parties. Therefore, a lawyer's reliance on or submission of a GAI tool's output without an appropriate degree of independent verification or review of its output could violate the duty of competent representation. And before moving on, I want to point out that Opinion 512 also speaks to the OG lawyers in the House, those lawyers who are charged with managerial and supervisory responsibilities. Such lawyers must take reasonable efforts to ensure that firm personnel comply with their professional obligations in using Gen AI tools. Not surprisingly, the opinion sets forth elements of a comprehensive training program as a means of ensuring that those obligations are complied with. The requirement of technological competence can be distilled into two words: AI literacy. Okay, it's one word and two letters, but you get my point. You see, the thing is, not only is AI literacy required by the rules, but it also becomes a key differentiator for those seeking a career in today's legal environment. So let's expand our discussion beyond AI literacy as a professional obligation to AI literacy as a competitive advantage. The professional legal landscape today is characterized by rapid technological advancements, evolving business needs, and a shifting workforce demographic. To remain competitive, individual professionals must prioritize continuous learning and development with a particular focus on AI proficiency. As one commentator observed, in this rapidly changing environment, lawyers with a multifaceted set of skills or versatility with AI may prove more valuable to potential employers. And I submit, lawyers and firms with those skills will be more valuable to potential clients. Making the point, one legal staffing entity recently tracked the largest revenue increase, a whopping 14%, in base compensation adjustments for legal professionals who are AI-enabled, meaning the employee is leveraging some form of AI daily in their work, or their current position, the lawyer is specializing in AI law or governance. But to achieve this competitive advantage, additional skills will be required. We are taken back to one of our enduring truths: our education and training must continue. As an initial matter, one must invest in digital skills. This means prioritizing training, experimentation, and comfort with these new tools. Included in this will be becoming proficient at prompting strategies, understanding GAI's limitations, and having strategies at the ready to minimize them, and staying on top of cutting-edge things as new strategies, things like agentic AI, develop. Once you develop this familiarity with the tools, your marketability increases dramatically, and you are prepared to occupy that space and perform those tasks that AI cannot. Broadly, I put such tasks into two categories. One, engineering and implementing processes and methodologies for legal teams where AI can best help. And two, applying the new capabilities AI affords us to the legal issues and problems our clients present. The two are related, but let me discuss the engineering point first. The widespread engagement of AI across the legal industry points to a future where legal practices are increasingly augmented by AI technologies, with the aim of creating a more dynamic, responsive, and client-centered legal landscape. We, as lawyers and other legal professionals, are uniquely positioned to be at the forefront of legal tech innovation, as we are ultimately familiar with the parts of the legal process and how they may benefit from augmentation. And we have a clearer idea of how legal tech products should be packaged in a way that firms and clients will accept. So examples of this include redesigning workflows to integrate AI where it adds value while preserving oversight and accountability. Building cross-functional teams, partnerships with IT, compliance, finance, business units, and in order to maximize adoption and minimize risk. Fostering adaptability within teams and encouraging a culture of continuous learning. Then there's the application bucket. Application means bringing AI skills to the table and combining them with those talents that are unique to this audience of trained legal professionals. As we've touched on before, those talents are judgment, creativity, the ability to strategize, emotional intelligence, and the ability to persuade. But let's get specific. Use AI to generate an outline of a brief or a legal research memo, but you do the legal research to determine how it applies to your specific fact pattern as well as your judge, client, or colleague within the firm. Use AI to go through thousands of pages, but you decide what's important for the deposition you're taking tomorrow. Use AI to create timelines, but you connect those facts to a story that a jury will connect with. Use AI to research the judge in front of you and get a feel of how he or she has ruled in similar issues in the past, but you determine how to use that information applied to the facts of your hearing. And most importantly, you stand at the gate in determining the correctness and appropriateness of any given AI output. As I work toward my conclusion, there's one final topic I particularly wanted to lift out. I want to talk about the potential AI has in helping bridge what we call the access to justice gap. When people talk about the justice gap, they usually describe the mismatch between legal needs of low and middle income individuals and families and the limited resources available to them. The Legal Services Corporation estimates that 92% of substantial civil needs among low-income Americans are unmet. This translates into millions of Americans lacking adequate legal help from problems in domains like housing, healthcare, and protection from abuse. It is estimated that over 100 million Americans face civil justice problems pertaining to basic human needs, including matters related to shelter, sustenance, safety, health, and child custody. The World Justice Project's Rule of Law Index ranks the United States as 115th out of 142 countries for the accessibility and affordability of civil justice. Of the 46 wealthiest nations in the world, the United States ranks 46. Civil legal aid, typically delivered by nonprofit organizations funded in part by the LSC, remains the only recourse for many low-income individuals dealing with issues like eviction, domestic violence, and consumer debt. Yet the demand for this help far exceeds the supply. In 2024, the LSC documented that its partner organizations had to turn away roughly half of the eligible cases simply because there were not enough lawyers or staff to go around. Problems in criminal defense have proven even more daunting, threatening not only the rights of the accused, but the safety of society at large. The workloads of public defenders have become so overburdened, criminal cases are being dismissed for failure of defendants to have counsel. The attorneys who service these communities in civil as well as criminal contexts note that much of the work that is required of them to perform for their clients is high volume, highly repetitive, and can involve large caches of documents. Thus, the efficiency benefits AI can provide for the for-profit practice of law can similarly be used to address like concerns in other contexts. Indeed, especially in the civil context, there may be opportunities. One example can be found in using AI-powered tools to address frequently asked legal questions, explain complex concepts in a clear and concise manner, and assist users in identifying the relevant legal resources needed to solve cases. In this regard, AI might be able to better democratize legal knowledge, and make it more accessible and affordable. If used ethically, these tools can help legal aid organizations, pro bono lawyers, and court systems reach more people and offer faster and more affordable services. But, and as foreshadowed by our above discussion, the potential of AI in legal services also comes with significant challenges. There are concerns about AI's ability to handle complex legal issues where nuanced judgment and human empathy are necessary. Moreover, biases inherent in the data used to train AI algorithms can be especially pernicious in this space, leading to discriminatory outcomes and exacerbating existing inequalities and result in unjust legal advice. Acknowledging these tensions, though, what better place for this room and those otherwise listening to engage? To paraphrase one writer whose observation resonated with me, it is too easy for legal technology to purely address the issues of people like me in dusty offices of law firms for large corporations, all the while paying insufficient attention to those who could really benefit the most. So I encourage all of you, all of us, all of me, to start using the talents to consider these options as well. So in conclusion, something you've all been waiting for me to hear, I want to sound a voice of cautious encouragement to the legal tech community. Despite a turbulent legal environment, I submit that the profession has experience with changes in law and technology. And while the precise changes we will be experiencing in 2026 may be new, the fact of change, legal change and legal tech change, is not new. I want to be clear here that while I'm saying that we have faced headwinds before, my message is not, if you just relax and chill, everything's going to be all right. Some people know that riff. The enduring truths of this profession have always been exacting and demanding. That has not changed. From the standpoint of personal success, we have a range of related, enduring truths, many of which are rooted in the concept of character. They include intellectual and academic rigor, hard work, constant training, education, and experimentation, inquisitiveness, and perseverance. From the standpoint of professionalism, we've talked about those moral and ethical values, and I'm not afraid to use that word, values, embodied there. Justice. And let me be clear here, I say this not only as a litigator, but one who observes the current events. It is not the absence of conflict that reveals justice. It is the presence and fairness of equality that defines justice. And fairness, fair play is measured not by who wins or loses, but whether the playing field, in other words, the processes, the procedures, the access to tools are level and accessible to all of the parties. Truth-seeking, especially relevant to an eDiscovery context where fact development is central, there must be a valuing of and recognition of the centrality of truth. Said differently, we must eschew falsehood and misrepresentation as antithetical not only to our professional creed, but to our pursuit of a more perfect union. These truths which undergird professional success intertwine, and I challenge you and myself to pursue them both. And in doing so, we will honorably serve our profession, and it will be the best recourse to ensure your personal success within that profession. Thank you, and enjoy the rest of your conference.